Hi, my name is Aditya Gupta and today I will be talking about the concepts of invention, novelty, inventive step and industrial application. I hope that by the end of this module, you will not only understand each of these concepts, but will also get a flavor of how to apply each of them in a practical context. Let us start with an introduction on the concept of an invention. Invention is defined under the Patents Act under section 2 clause J. If you read section 2J, and I would recommend you to do so, you would find that there are three elements of an invention. Firstly, it must be new. In other terms, it must possess novelty. Secondly, it must have an inventive step. In some jurisdictions, this is also called the non-obviousness requirement, that is, the invention must not be obvious. And third, it must be capable of industrial application. These three requirements form the core tests of patentability under patent law. What is the subject matter of an invention? An invention can either be a product or a process. You would find these two words again in section 2 clause J. The Patent Act also contains certain statutory exclusions to patentability. These statutory exclusions are mentioned in section 3 of the Act. The statute creates a list of items that otherwise might have been considered as inventions, but has specifically created exceptions, and no patent can be granted to any item which features in the list mentioned in section 3. The Supreme Court in the Novartis case examined the relationship between section 2J, that is the concept of an invention, and the list of items mentioned in section 3 of the Act. The Supreme Court found that they create two separate filters, that is, even though a product or a process might be considered as an invention under section 2 clause J, it could still be denied a patent under section 3 if it fell within any of the lists of items that are enshrined in section 3 of the Act. Now, let us move on to the concept of novelty. Remember this test. A claim is considered new or novel if all the elements of the claim cannot be found in a single prior art reference. To understand this, you will need to understand the concept of a claim and the concept of prior art. A claim is that portion of a patent which describes the boundaries of the invention that the patentee is seeking to protect. Similarly, prior art is everything which is made available to the public before the priority date of the invention. To understand the concept of priority date, you could see section 11 of the Act. The most commonly used prior art references are prior documents which have been published prior to the priority date of the invention. Let us take an example. Let us take a claim regarding a chair. It would read as a device for resting comprising of a seating platform, 4 legs, a backrest and an armrest. The elements of this patent would be a device which must be used for resting. This means that it is a product patent. It must have a seating platform, it must have 4 legs, and it must have a backrest. It also lastly must have an armrest. Now, let us take a prior art reference. This could be contained in a prior patent which discloses the following elements: a device for resting, a seating platform, 4 legs, a backrest. Do you now see the difference between this prior art reference and the elements disclosed by the claim? You would find that the prior art reference did not disclose an armrest. Therefore, the novelty of the patent for the chair with an armrest would not be destroyed. Here, remember, to conduct a novelty analysis, you cannot do mosaicing. That is, the novelty analysis can only be conducted with reference to a single prior art reference, meaning that you can only look at the elements disclosed by one document. Let us say there was another document which disclosed a chair without a backrest, but with an armrest, you could not have combined the two documents to destroy the novelty of the claimed invention. Therefore, no mosaicing of two prior art references is possible while conducting a novelty analysis. Now, let us discuss the concept of an inventive step. The term inventive step has been defined in section 2JA of the Patents Act. The Supreme Court in the Novartis case also considered this definition and found that the inventive step has the following elements. That is, the product must come into being as a result of an invention which has a feature that entails a technical advance over existing knowledge or has an economic significance and that makes the invention not obvious to a person skilled in the art. Therefore, the patentee has to identify a feature by virtue of which his patent, his invention has a technical advance over existing knowledge. That is, he must identify something which makes his invention worthy of a patent. He could also rely on an economic significance that the patented invention has. For instance, let us say someone comes up with a method of making a drug which is much cheaper than the existing methods. Let us say he reduces the cost of the drug by 100 times. This invention, even though it does not lead to a technical advance necessarily, could still be granted a patent under the second prong of the test as identified by the Supreme Court. Let us look at the policy consideration in an inventive step analysis. The court or the patent office, while considering the concept of an inventive step, basically considers whether a patented invention is inventive enough to deserve a patent. See, there are always some incremental obvious improvements that one can make to the existing knowledge, but such incremental obvious improvements are not worthy of a patent. Remember, a patent monopoly grants you exclusive rights for 20 years, and therefore, the courts and the tribunals have set a rather high threshold for considering for determining what an invention is. It must be a long jump or a leap of sorts. Let us look at a few concepts which go into defining what is an inventive step. Firstly, you have to understand the test of obviousness is considered from the point of view of a person skilled in the art. This is a term of the art and you would find this reference again and again in patent jurisprudence. A person skilled in the art is not an inventor. He does not have inventive faculty. He is not considered to be imaginative. He is a person of average normal skills. This is a very important concept in patent law, especially since if the threshold for a person skilled in the art is kept at a very high level, let us say that of an inventor, then probably no invention would be considered to be non-obvious and everything would be denied a patent. Similarly, if the skill level of a person skilled in the art is kept at a very low level, let us say that of a person on the street, then several inventions which would be otherwise not be worthy of a patent would still be granted a patent, since it would appear non-obvious to a person on the street. Remember that the person skilled in the art also has to be from the relevant field of art. Therefore, for instance, for a invention from the field of physics, a person from the field of physics may be a BSc, an MSc or a PhD may be considered. The next question that we will consider is obvious with respect to what? As you would have noticed from the definition mentioned in section 2JA of the Patents Act, the technical advance that a patentee must show is that over existing knowledge. That is, whatever existed before the priority date of the invention can be considered to determine whether what the patentee has done has an inventive step or not. Does it have a leap or not? Remember, as opposed to novelty, while conducting an inventive step analysis, mosaicing is allowed. That is, you can combine the knowledge from different documents to see whether the invention claimed has an inventive step or not. But it is not as if you can keep combining hundreds of documents to see whether an invention is obvious or not. It is also important to know whether a person skilled in the art working on that particular problem would have combined the teachings from those two documents.